If you're going through a divorce, it's important to understand the differences between sole custody and joint custody so you know which is best for your family. How can parents possibly choose who gets to spend more time with the children? There isn't often a clear answer, so let's dig into the intricacies so that you can find the right path for your family. With sole custody, one parent has exclusive legal and physical custody of a child, making them responsible for the child's care and important decisions about them. It's important to note that sole custody does not always mean that the non-custodial parent has no contact with the child. In most cases, the court will establish visitation arrangements that allow the non-custodial parent to maintain a relationship with the child while ensuring the child's safety. With joint custody, there tends to be more variables involved. In joint custody, both parents share the responsibility for making important decisions about their child's upbringing and welfare. They also share physical custody, but the degree to which custody is shared varies. In other words, joint custody doesn't have to be 50-50. Some may involve one parent having more substantial physical custody than the other. This is primary physical custody. In most cases, joint custody is best for the child. So how can you decide which type of custody arrangement is right for you and your family? Here is a list of some of the considerations that can help you make this challenging decision. Parental cooperation. Joint custody requires a lot of cooperation and communication between parents. If you and the other parent can work together, joint custody can be a great option. However, if there is a history of conflict, it may not be in the child's best interest right away. Both parents need to commit to overcoming their personal issues in order to create stability for the child's best interest. Courts prioritize the child's physical, emotional, and psychological health above all else. Parents may not be happy with the decision, but the child's well-being is paramount. Stability and routine. Children need stability and routine. If joint custody will disrupt their daily life, or one parent is incapable of providing a stable environment, this could be a factor. In cases where one parent moves away or even to a different school district, one parent may have to have more custody than the other. Proximity. If parents live far apart, it may be challenging for the child to transition between homes regularly. It's okay for a parent to move, but they should consider how that may affect their custody agreement. In many cases, this child will stay with the parent who isn't moving unless there are extenuating circumstances. The child's age. The child's age and developmental stage will likely be taken into account when a judge is determining custody. Younger children may require more stability and predictability. Older children may better adapt to shared custody arrangements. When it comes to older children, their opinion may also be taken into account. Younger children who are breastfeeding may have to stay with the mother. However, if only one parent has the ability to provide daycare for a child who's too young for school, that may also be a factor. Parental involvement. The judge will assess each parent's level of involvement in the child's life. Courts often favor shared custody when both parents are actively involved and committed to the child's upbringing. Both parents should be making decisions and spending near equal amount of time with the child. If one parent is already borderline absent, the judge will keep that in mind. Each parent's abilities. Each parent's ability to provide a safe, nurturing, and supportive environment for the child should be assessed. This includes considering each parent's work schedule, living conditions, and support systems. In many cases, a parent who works longer hours and doesn't have enough space for a child will get split custody, but they'll have less physical custody than the other parent. It's uncommon for a parent to have no custody at all for these reasons alone. History of abuse or neglect. Any history of abuse or neglect by either parent can be a significant factor in custody decisions. If the parent has ever abused the child or the other parent, it may mean that the other parent gets sole custody. It's possible that the parent could get visitation or earn their right to joint custody back, but it's not guaranteed. There's nothing wrong with asking for help when you're in this situation. In most cases, having a lawyer on your side is best for your child. The lawyer understands that this is an emotionally turbulent discussion, and they will be able to approach it from a level-headed perspective. If the other parent has an attorney, it's imperative that you have one as well. You want to make the playing field as even as possible if you want a fair outcome for both parents as well as the child. It's your responsibility to work with an attorney to make the right decision. Contact Blattner Family Law Group today.